Hi, everyone. So, as you've noticed by now, we in class on Monday watched a movie called The Last Abortion Clinic. And so, as a result, because we don't have class on Wednesday, meaning I'm out the entire week, I want to make sure that we can hit the ground running the following Monday with the beginning of part two of the class. And so, as a result, I'm going to post these slides. Basically, it's just finishing what we talked about in class last Wednesday, which is the constraints of the court. So I wanted to briefly review the doctrinal constraint and then continue talking about institutional constraints and then cover cultural constraints and sum it up with the dynamic and constrained court view. So just as a reminder, again, no class next Wednesday. And today we'll be talking about the limits of law in courts, doctrinal constraints, as I mentioned, finishing institutional constraints, and then finally cultural constraints. Summing up with the dynamic and constrained court view debate, which really is the culmination of part one of this course. And we'll review the DCV, CCV, and class next week. But for now, this is basically where we left off in class on Wednesday. So when we're looking at the institutional constraints, remember that the internal institutional constraint, one part of it concerns how courts are themselves organized. And there was a German sociologist, in fact, he invented the field of sociology, named Max Weber. And Max Weber wrote about institutions and specifically bureaucracies and identified some sort of key factors that make organizations run really well. And basically, he figured out that any organization, whether it's a company or a government institution or whatever, if it has a very clear chain of command, if the rules and procedures are really clear, and if the level of specialization within the organization is high, then it's a well-functioning, ideal type bureaucracy. And you can even see the same like in your college classes, for example. So imagine a class where it's super muddled as to you don't know who to talk to about problems like the professor or the GA. The rules and procedures are either not posted or they're very unclear. And the level of specialization is also not clear, meaning the professor, gives the class over to the students to talk, through the whole class or whatever, right? Whatever it is, you can imagine that would be somewhat of a frustrating experience. And so it's useful then for us if we think of if we're going to claim that the courts are a policymaker, then we should sort of put them on trial, so to speak, and see how they hold up against other institutions, and specifically Max Weber's ideal institution. And so we know because there are 13 courts of appeals in the US and obviously the DC Circuit Court of Appeals too, and they exist sort of on a horizontal plane, that the chain of command there is pretty muddled and pretty balkanized. Of course, you have the U.S. Supreme Court at the top of the food chain, but those courts exist below the Supreme Court at the federal level, and we'll talk much more about this next week, but they can issue oftentimes conflicting rulings. It's not sort of clear where jurisdiction lies and so on. And also, despite the sort of government's best effort to streamline the rules process, the rules and procedures that surround court-based policymaking are very complex. And we'll talk more about this again later, but this is not, it doesn't have to be like this, right? One of the reasons why attorneys, lawyers are seen as being, quote unquote smart or quote unquote capable is because they're able to navigate this really complicated rule process. But always remember that it is in their best interest to keep these rules complicated, right? Because otherwise you would not need their services. And so the rules and procedures surrounding court-based policymaking are very unclear. And then as we talked about last week, judges who are often making these decisions are not trained in the sort of substantive area in which the decision lies, like, for example, economics, healthcare policy, marriage. There are trained experts in those fields. Those are not judges, right? Judges are trained to be lawyers for the most part. And now there is some specialization we see in bigger cities. For example, there are drug courts where judges receive specialized training in how to deal with people that are addicted to drugs, or divorce courts or whatever. But by and large, the level of specialization, with some exceptions, is pretty low. All right, so moving on. All things being equal, courts that are internally fragmented won't act in a coordinated fashion. And this can really significantly limit judicial power, obviously, because one court can't speak for another, as well as judicial coercion, because the courts just simply cannot speak in a single voice. And so then it's hard for organizations that are the subject of policymaking to listen. All right, so moving on to the final constraint, which is culture. Um, we're going to spend a little bit less time on this. And the reason why we need to spend, or we're going to spend a little less time, is, of course, this sort of fundamental aspect of the federal judicial system, which is that judges are unelected. And so in our elected branches, we see that there is a direct link between the public and the elected official. And that direct link comes in the form of an election. And so while it's very much the subject of debate whether the politician shapes the views of the public or the public shapes the views of the politician, the reality is probably somewhere in the middle. Um, they have to pay attention to one another, right? Politicians in particular have to pay attention to the public and the culture and opinions on things, because if they don't, they'll A, never be elected in the first place, or B, if they lose sight of what that opinion is, they won't win re-election. Judges, though, are in a different boat because they're unelected, and so as a result, they exist within the culture but are not linked to it via elections, right? And we talked about this last week with respect to the hypothetical of federal judges, for example, legalizing gay marriage in the 1800s. Why would they not do that? They're not elected. They couldn't be punished for it. Well, they still pay attention to the culture. And secondly, they're products of the culture themselves, right? They're not legal robots. And so cultural constraints are limits on the court then that stem from elite or public opinion. And examples here in the reading include the war on drugs, Mexico's war on drugs, and the falling child case from the Bronx, the apartment in the Bronx. And so we can talk more about this next week in person, but those are some examples of how to flesh out cultural constraints. All right, so to sum up, we have three constraints: doctrinal, institutional, and cultural. Doctrinal constraints, remember, are written down, right? So the source of that particular constraint on the court is the law itself. As for institutional constraints, internally, the source of the constraint is how courts are organized, and on the exterior, it's how courts interact with other branches of government. And then finally, the source of cultural constraints are elite and public opinion. And remember, each of these constraints applies to both power and coercion. Power meaning the ability for the courts to enter the policy-making game at all, and coercion referring to their ability to actually have people listen to them. And so the constraints on power with respect to doctrine deal with justiciability, which, if you remember, deals with jurisdiction. So sometimes a court just cannot take a case, right? Because they don't have jurisdiction. The rules mean that they can't do that. As for coercion, we'll talk more about this later in the semester, but remedy laws are an example of this. And remedy law is basically limits a plaintiff's ability to get money in the case of an injury or breach of contract. And again, we'll talk more about that later. As for the institutional constraint, the constraints on power deal with the fragmentation of the courts as well as their passivity. Remember, even though the barriers to entry are pretty low in the court system, judges still cannot necessarily decide exactly what they want to deal with, right? They're like a Venus flytrap. They've got to wait for the insect or the case, in this case, to come to them. And as for coercion, courts are very inefficient. Again, dealing with their organization, they're not a sort of ideal bureaucracy, and also they're subjected to the checks and balances of the other branches. As for constraints on power, at the cultural level, there's some reluctance of judges to sometimes hear issues that they think the culture is not ready for, and also there can be a resistance of a target subculture with respect to constraints on coercion. And so if we put these constraints together, we end up with the CCV versus DCV, which is the constrained and dynamic court debate. And this stems from Gerald Rosenberg, who's a professor at the University of Chicago, wrote this book in 1991 called The Hollow Hope, which refers to the power of the American court system. And basically he asked this question: are the law and courts a powerful and effective player in the policy-making game, or are they limited in what they can accomplish when it comes to policy-making, right? In other words, are they dynamic or are they constrained? And describing the courts in this dichotomous way allows us to set up competing explanations on the one hand, identify observable implications and the assumptions of those implications on the other hand, and then probe those assumptions in the light of the available data. And this process is actually super central to generating research and generating social science research in particular. And generating and probing hypotheses is what makes us political scientists and um, sort of separates us from journalists and historians. As important as those fields are, that's more of a descriptive world, and we're in the business of providing explanations. All right, so this is a chart. Again, I will go over this in greater detail in class next Monday. So again, this is going to kind of be the backbone of the rest of the course. And we're going to go through these one by one. So we've got this sort of core metaphor, which we'll discuss in a second. Then we've got the doctrinal constraints, internal institutional, external institutional, cultural constraints, as well as the implicit conception of politics that is associated with each view. And so the core metaphor of the constrained court view is what we refer to as the principal-agent relationship. And this is where courts often do the bidding of the other branches. So in the principal-agent relationship, which is a term that comes from economics, the principal controls the agent, right? So they do not act on their own. The agent is simply a function of what the principal wants. And so in this case, the courts are simply a function of what the elected branches want. In the constrained court view, doctrinal constraints are very strong or are very high. This is especially true given that the law is socially constructed. I'll say more about that later. Internal institutional constraints are also pretty high, right? The courts are very passive. They're dependent on lawyers to bring them information, as well as they're subjected to uneven resources, right? So even if they want to help a party, policy-wise, if that party does not have the money to afford, good representation, or if their, lawyers aren't any good or whatever, then the courts are going to be limited in their ability to hear in favor of that party. And finally, fragmentation is a big deal, as conservative and liberal circuit courts, like the Fifth Circuit Court, which is where we are, has a reputation for political conservatism, and like the Ninth Circuit Court on the West Coast is seen as very liberal, yet those courts are at the same level of the federal court system, and so they can often issue contradictory rulings. As for external institutional constraints, courts are, of course, subjected to the appointment process. As we talked about with the Antonin Scalia vacancy, the court was left with 8 members for the better part of a year in 2016, when Republicans in the Senate refused to grant Merrick Garland, who was Barack Obama's appointee, to fill his seat, hearings for his confirmation. And so as a result, the court was really hamstrung by having an even number of justices, yet they couldn't do anything about it. And finally, the cultural constraints are strong as well, because the court does not have the power of the purse and needs to be able to persuade the public, essentially, that what they're saying is legitimate. And this is where the rule of law comes into play. And so here the implicit conception of politics then is very Laswellian. So if you remember, we talked about this definition of politics a week or two ago from Harold Laswell. And Harold Laswell says that the politics is really about who gets what, when, where, and how, right? And this is super sort of an apt description of politics for the constrained court view, because essentially it says, look, if we're going to define politics as a distribution of goods and services, then how effective is the court at doing that? And the answer is not very effective, right? So if you think of desegregation, for example, as a good or a service, we saw that the court entered the game. They desegregated the schools. But then if you looked 20 years later, 1974, a large, enormous, in fact, percentage of public schools in the South were still segregated. And so if we're thinking then of the court as like going to hand out little desegregation goodies, then they didn't do a very good job of it, right? Okay, so then moving on, and by the way, Rosenberg argues in The Hollow Hope that that's what the courts are. They're a hollow hope for activists. They're like a mirage in the desert. because they are, for the most part, constrained. The opposite argument is that courts are, in fact, dynamic. And that rather than being a part of a principal-agent relationship, they're instead what we call independent centers of power, right? Federalist 48 and 41 suggest to us that powers in the United States are separated among three different institutions, and yet those powers are shared, right? The branches overlap in many ways, but they are, in fact, independent centers of power. Doctrinal constraints, rather than being strong, are in fact weak, right? Again, like think of the necessary and proper clause in the Constitution. What does that mean? Well, it says whatever judges say that it means, right? And yes, judges are sometimes hamstrung by specific language of the law, like in the case of the Flood Control Act of 1928, or the Fugitive Slave Act, right, when abolitionist judges were forced to return slaves to the South. But for the most part, doctrinal constraints are pretty weak. As for internal institutional constraints, the bar for bringing lawsuits is really low. And in the grand scheme of things, it's pretty cheap. Litigants are afforded really broad standing rules, meaning it's not hard to convince a judge that it's okay for them to sue. And also, this country just has tons of lawyers, and that number is growing. And also, broad powers of injunction have put the courts in control of federal prisons, some school systems, etc. As for external institutional constraints, yes, judges are unable to self-select their peer judges, but once they, are confirmed, it's important to remember that they serve for life, right? And so those external institutional constraints are actually pretty low because, yes, they've got to get placed on the court in the first place, but once they're there forever. And finally, cultural constraints are weak given the American creed and the grab bag of values with vague terms like we talked about a couple weeks ago: equality, liberty, freedom, etc. Judges can use those words as a hook, right? So gay marriage can be couched as the plaintiffs exercising their freedom. But then likewise, opponents of gay marriage can talk about how they have religious objections to the institution of gay marriage, and they are also exercising their religious freedoms in objecting, right? So you can see how these, whether you agree with that or not is beside the point, but these values can really be placed in multiple contexts. And then finally, the implicit conception of politics with respect to the dynamic court view is that preferences are very fluid, and that politics is much more about the distribution of goods and services. In fact, it's about placing things on the agenda. And so in the case of Brown, right, we saw that the court was not necessarily successful at doling out desegregation to school districts in the South right after Brown. But what they were successful at doing is giving policymakers and especially elected officials like Congress, LBJ, et cetera, a sort of hook, a sort of reason to pursue legislative solutions to the problem of Jim Crow and of desegregation. So again, I know this chart is a lot to handle, especially via a YouTube video, but we will cover it much more in depth in class next week. And so in the meantime, feel free to reach out if you have any questions, and I'll see you soon. Thanks.